Good morning and a very warm welcome to our webinar, Exploring Dora. What could be more interesting on a Tuesday morning? We want to give you, in the next hour, an overview and a very concrete idea on how Dora will impact your business. My name is Verena Ritter-Döring. I'm heading the Financial Regulatory Group here in Frankfurt at Taylor Wessing in Germany. And I have brought with me today two of my very able colleagues. So we have here Claire Reynolds, she's from our London office, and Miroslav Juric, she's part of my team here in Frankfurt. And both are experts on IT regulation and fintech business models, but are also very familiar with the common, normal financial regulatory law as such. A short organizational remark in the beginning. This webinar will be recorded and you all will receive with a follow-up email a link to the recording. If you also want to wish to get the presentation, just send us an email and we will send it to you as well. And if you have questions in between, we have a sidebar in this program here which says questions on the bottom, and you can type in your questions. The questions will only be seen by us and we will try to answer it in between, or if this is if there's no time for it, we will do it in the end. So in the end, there will also be time for your questions. And please, it would be really good to have a bit of a dialogue so we can actually give you the answers you want to receive, so that it really has an impact on you. So let's get started. So this is just our agenda. So let's just dive in. So we will talk about Dora today. Dora is came a bit slow, but it will have quite an impact on the financial market. Dora is part of the EU Digital Finance Package, which was published 2.5 years ago. The ever-increasing dependency of the financial sector on software and also digital processes means that IT risks are inherent in finance and the financial market as such. So IT risks and the risk of cyber attacks are part of every IT infrastructure. So the EU thought we would like to have something that gives our infrastructure and our financial market a bit more security. And the result is Dora. So Dora is only one part of the EU Digital Finance Package, but that's the one part we are looking at today. So what did we get? We did get in December 2022, so last December, 27th, so really end of the year, Dora was adopted by the EU Parliament, and we have a regulation and a directive. So when we talk about Dora, we usually talk about the regulation, because the regulation will be applicable in all over Europe as such. And then we also have a directive. I will come to this in a minute. But the regulation is actually the basic part of Dora. So what do we want to do? We want to strengthen the IT infrastructure all over Europe, and we want to create a harmonized regulatory framework on the management of the IT risks. So, and we all have bits of this already. In every EU country, we have bits and pieces of it, and it also might work very well, but we do not have an harmonized framework, and this is what we will get now. So Dora will enter into force, or entered into force in January this year, and we have 2 years to actually implement everything, and then the Dora will start to apply in January 2025. So we will think It's 2 years, it's a long time, it's not a long time. It's actually really not a long time. So it's good to get started. And also in Germany, you know, we are usually gold plating everything that comes from the EU. We have lots of IT regulation and supervisory guidance already, like BIT and so on. This whole BaFin publications, everyone will know anyway, but compliance with the current regime will not be compliance with Dora. So there is actually something we need to do. So who's in the scope? As you can think, all financial institutions, obviously, because we want to regulate the financial market further. The new part is we also have an oversight framework included in Dora for IT service providers who provide cloud computing and things like this. So IT service providers are also covered. That's what we here mean with third-party ICT service providers. This is new and it goes beyond the scope of what we already have at the moment. And then there are micro enterprises also covered, but they get a reduced regime. So I will skip this here. So, and if we look at the framework, the regulatory framework we currently have, we have the EBA guidelines on outsourcing. Okay, this will continue to apply. They might be amended a little bit. Because Dora has a broader scope of application, and the third-party ICT service providers will bear a more heavy regulation from 2025 on. So please be aware that you have to, if you are a financial institution, you probably already started, but if not, please get a very concrete idea what will happen. So, and before I let the experts speak, I would like to also set out the regulatory landscape a little bit. So we have the sector-specific regulations on an EU level, you know, like MiFID, MiFIR, but also the IFR, the investment firm regulation, which also belongs here actually, for the investment firms. Then we have the CRR and CRD for the banking sector. We have UCITS and AIFMD for the fund sector, PSD2 and the e-money directive for the payment service sector. So, and all of those already contain bits and pieces of IT risk management regulation. So, and then this partly is also implemented in national law. So we just listed here the German ones. And in addition to this, we have the level 3 regulatory requirements and also the BaFin guidance or the guidance from the competent authority in each member state. So we have this already, and all of those are IT regulation requirements already. And now we get Dora on the side, and we will go into more detail what will happen. But just to give you the idea, the impact of Dora will be on every level of those. The Dora directive will change or amend the EU level regulation, and then it will, from there, it will trigger down. Yes, so the directive will change the EU level, and then the regulation will be on the side and also change all of those. So, and for more detail, I'll hand over to Miroslav.
Thank you, Verena. So we're going to now take a brief overview of the new framework. And before diving into the specifics, so let's see first how Dora fits into the existing EU regulatory landscape. So the package comprises of the regulation and the accompanying directive. Dora as a regulation, which contains all the most important requirements, is going to be directly applicable across all EU 27 without any need for national transposition. That being said, as of 17th of January 2025, these new requirements are going to directly apply to regulated in-scope entities operating in the European Union. On the other side, on the right-hand side of the slide, the accompanying directive is going to make a targeted adjustments to the sector-specific regulations in the EU. For instance, MiFID II, CRD, as well as PSD2 and the UCITS AFMD framework. The aim of these changes is basically to harmonize the existing requirements on outsourcing arrangements and management of ICT risks at a sector-specific level, and these targeted adjustments will need to be implemented into national law. So in the blue row, for instance, here we see some examples of German regulations such as German Investment Firms Act, Banking Act, Payment Services Act, as well as Capital Investment Act that are going to be slightly amended as a result thereof, and these additional requirements will also then directly apply to regulated entities. On the left-hand side of the slide, we see the ESMA guidelines on outsourcing that Verena briefly mentioned before. These will continue to apply to outsourcing arrangements. However, as she mentioned before, they have slightly narrower scope of application in comparison to Dora, because they're going to be still focusing solely on outsourcing arrangements, whereas Dora has slightly broader scope of application. Dora, first and foremost, imposes new requirements on the boards of the regulated entities that have obligation to establish proper internal governance and control frameworks that are aimed to ensure effective and prudent management of all ICT risks. ICT stands for Information Communication Technology. Risks that are in Dora defined quite broadly as any reasonably identifiable circumstance in relation to the use of network and information systems, which, if materialized, may compromise the security of the network and information systems, or any technology-dependent tool, process, operation or process, or the provision of the regulated service itself by producing adverse effects in either digital or physical environment, which is really important to emphasize because we hear a lot of people talking about Dora as a piece of EU regulation that is only addressing risks in the cybersecurity space, which is not entirely accurate. For the purposes of establishing of proper arrangements enabling this effective management of ICT risks, the management boards of the regulated entities will need to ensure clear allocation of roles and responsibilities for all ICT-related functions. They will also need to start with the determination of the risk tolerance level of the firm in relation to ICT risks, which is going to be largely dependent on the types of systems the firm uses, the level of digitization in terms of the provision of services to the clients, and so on and so on. Firms will also need to allocate appropriate monetary resources necessary for proper fulfillment of the firm's needs in relation to its digital operational resilience. So in terms of the technical equipment, organizational structure, trainings for the staff, and so on and so on. And with that in mind, boards will also need to ensure that the core staff, is provided with regular trainings on ICT-related topics so that they can stay up to date with the latest developments. The implementation of Dora requirements is gonna actually require a lot of new documentation, especially for some entities that are not subject to some existing regulations at a national level. On the right-hand side of the slide, we see a list of some of the core documents, which include digital operational resilience strategy, business continuity policies, disaster and recovery policies, information security policies, and so on and so on. But we will dive into that in more detail a bit later. The ICT Risk Management Framework under Dora basically comprises of, let's say, four main pillars. So first, firms will be required to develop strategies, policies, procedures, tools, and protocols for the effective protection of ICT infrastructure and for the minimization of ICT risks. Second, they will also need to establish a comprehensive and solid information security management framework that is developed in accordance with international standards, and this will all need to be documented in the information security policy, whose main aim is really to ensure confidentiality and availability of relevant data necessary for the proper functioning of the firm and the provision of the regulated services. One key pillar of the ICT risk management framework is also a proper segregation of ICT management functions that will need to be properly segregated from other control functions such as compliance, AML, and so on, and the internal audit function, which has an important role to play also in the DORA framework, and we're going to come to that a bit later. It is recommended in the regulation that entities can basically use either a well-known three-line of defense strategy or internal risk management and control model. And last but not least, the risk management framework will have to be adequately documented in the form of a comprehensive risk management policy. The entire framework needs to be reviewed once a year or on an event-driven basis. And as I mentioned before, internal audit has an important role to play in the new framework. Mandatory audit of the ICT risk management framework is required under DORA on a regular basis by applying a risk-based approach, which is probably going to be annual basis. All of this is really intended to be based on a very comprehensive digital operational resilience strategy that regulated entities will need to prepare and develop. This strategy needs to set out how the ICT risk management framework of the firm is implemented by explaining and outlining how the ICT risk management framework is in line with the entity's business strategy and objectives. Also, it will need to outline different mechanisms that the firm has put in place for the purposes of detection of ICT risks and incidents, protection and prevention of impacts of the ICT related incidents, and so on. And this document will also need to define clear information security objectives of the firm. This digital operational resilience strategy needs to be approved by the board of the company. It needs to include key performance indicators and key risk metrics based on which relevant exposures to ICT risks are being measured. It shall also include a communication strategy for disclosure of ICT incidents. We're going to come to this a bit later, but basically the idea is that under DORA, once the ICT incident occurs, the regulated firms will need to clearly communicate this both internally but also externally to their clients, counterparts, but also to report them in certain cases to the national competent authorities. And the digital operational resilience strategy will have to detail how the financial entity implements digital operational resilience testing requirements that we're going to explain a bit later. In terms of the ICT risk management framework, we can really classify this in six main to-dos for the regulated firms that first and foremost need to identify, classify, and document all ICT management functions and sources of ICT risks for the firm based on the type of its business activities and exposure to ICT risks. They will also need to perform annual or event-driven ICT risk assessment, as mentioned before. And in the second instance, firms will need to ensure proper level of protection and prevention of ICT risks through the implementation of adequate systems and procedures for continuous monitoring and control of ICT risks. That basically shall include adequate access, authentication, change management systems and procedures, as well as counter cyber attacks systems and procedures. Under Dora, firms are also required to detect any kind of anomalous activities, ICT network performance issues, and ICT-related incidents. They will need to implement proper systems that will provide for this detection, and they need to use detection mechanisms based on basically multiple layers of controls with defined alert thresholds and criteria based on which basically immediately following the occurrence of the ICT related incidents, the ICT related incident response process is activated. For instance, alert mechanisms for responsible staff that would be immediately triggered following detection of the ICT incident. Based on the past experiences, firms are required to, so to say, learn and evolve, and in order to analyze occurred ICT incidents and then to implement the lessons learned into their ICT risk management framework so that similar events can be prevented properly in the future. Firms are also required to properly respond to ICT disruptions and ensure recovery from ICT incidents. They will have to implement effective business continuity mechanisms based on the ICT business continuity policy. That shall be a quite comprehensive document and outlining all internal steps and measures that the firm is taking for the purposes of ensuring business continuity. As part of this framework, firms will also need to prepare ICT disaster recovery plans. So basically, that following the occurrence of the ICT risk incident, they are basically technically able to recover from any harm done in the course of such incident. Firms are also required to designate one crisis management person. So this will be an internal function that will be responsible for the oversight of this part of the DORA framework. And it will be required for firms to set up backup systems that can be activated in accordance with the internal policies, which ensure that essential data is being backed up on a regular basis and thereby properly protected from any harm that can be done through the ICT incidents. In the field of communication, as mentioned before, it is very crucial under DORA that firms establish effective communication channels for the disclosure of ICT-related incidents, both to their clients and their counterparts. They will need to prepare internal communication policies that will explain in detail to internal staff how they are how they need to communicate these events following their occurrence. And for this purpose, firms will also need to designate one person who is going to be responsible for the firm's communication strategy, basically. DORA also brings new requirements on the reporting of the ICT incidents, and for the first time provides for a harmonized framework on the reporting of ICT incidents across various subsectors of the financial services sector. Basically, identified ICT incidents will first need to be classified in accordance with the following criteria. First, number of clients affected, clients, counterparts, and so on and so on. Duration, including duration of the incident, including the service downtime, so the time span within which the regulated service was not provided, geographical spread of the ICT incident, any data losses incurred, severity of the impact, as well as the criticality of the regulated service which was affected, and the economic impact in terms of the costs of the incident. It is important to mention that under Dora, only major ICT incidents need to be reported to national competent authorities in accordance with the requirements on the reporting procedure. And financial entities, in addition to this, may, on a voluntary basis, notify significant cyber threats to the NCAs when they deem the threat to be of relevance to the financial systems, service users, or their clients. It is important to stress at this point that Dora does not replace in any way whatsoever the existing reporting obligation that are stipulated under other pieces of EU regulation, like, for instance, the obligation to report data breaches under the GDPR framework. Under Dora, the reporting process, as we can see on the right-hand side of the slide, is intended to look as follows. First, immediately following the occurrence of the ICT incident, major ICT incident, regulator firms need to send the initial report to the NCA without delay. Second is the intermediate report that is to be sent to the NCA following the initial notification, and that needs to be sent basically in 3 cases. So first, as soon as the status of the original incident has changed significantly. Second, where the handling of the major ICT incident has changed based on new information that firm has obtained in the process. And third, where the NCA explicitly requires the firm to send the intermediate report. The last report that firms will need to file with the NCA is the final report, which needs to be sent to the NCA when the root cause analysis of the incident that has occurred has been completed, regardless of whether mitigation measures have already been implemented or not. It is important to mention that in the original proposal, which was published in September 2020, we saw some deadlines, so time limits when these reports need to be filed with the NCAs. This has changed in the meantime, and in the final text, the EU lawmakers have agreed that these time limits for each report will be actually specified in the RTS that European supervisory authorities need to develop in the coming period, and basically they're going to be published alongside the reporting templates that ESAs will develop in the coming period. And last but not least, from my side, under Dora, we also have some new testing requirements, which is quite a novelty. As part of the ICT Risk Management Framework, firms will be required to establish a comprehensive digital operational resilience testing program, the so-called DRTP. DRTP basically needs to enable firms to assess their preparedness for ICT-related incidents and to identify weaknesses, deficiencies, and/or gaps in their digital operational resilience. DRTP basically shall establish a basis for the execution of various assessments and analysis, among other vulnerability assessments, open source analysis, network security assessments, gap analysis in terms of the ICT risk management, physical security of the premises where, for instance, servers, data centers are located, and so on and so on. This testing needs to be performed on an annual basis by independent parties. It's also important to mention here that in the original text, it was stipulated that external auditors were supposed to do this. However, in the final text, the EU lawmakers have left the space for the firms to do this also internally. So this testing can also be done by internal stakeholders who have certain level of internal independence. And in addition to general requirements, we also have specific requirements on advanced testing, the so-called thread-led penetration testing. these requirements will apply to a rather smaller group of financial institutions that will need to perform the testing of their systems by means of the so-called thread-led penetration testing. This is basically a testing method that mimics the real-time threats that firms may encounter in terms of the ICT operational resilience, or for instance, cyber attacks. And this testing will need to be performed by certified professional testing providers. These specialized entities will be certified by the accreditation body at the member state level. So in every member state, a specific accreditation body is going to be certifying service providers who are going to be able to perform this type of testing. And TLTP will need to be done every 3 years and shall cover at least critical and important functions. European supervisory authorities also have a mandate to develop RTS specifying criteria based on which it will be basically determined which entities shall be subject to this obligation. Among other, we see in the final text that operators of trading venues, large credit institutions, and so on will be subject to this requirements. However, in the recital 56 of the final text, we see that the EU lawmakers have emphasized that TLPT will be rather less relevant for certain subsectors of the financial services system, which include asset managers and credit rating agencies, for instance. That being said, I would now leave the floor to Claire, who's going to provide you with a bit more information on the management of ICT third-party risks under Dora.
Thanks very much, Miroslav. Yeah, as Miroslav mentioned, I'm going to talk a bit more about the part of Dora that deals with third-party risk, which is a significant component of Dora, I think because of the recognition of the risk that can arise with third parties that firms don't necessarily have so much control over. So there's two parts of this that I'm going to talk about. The first part is really around the harmonization of the requirements on firms in terms of how they address third-party risk. And then the second part is going to be talking a little bit more about that direct oversight regime for certain critical ICT third-party providers. But throughout this, we're really going to be looking at some of the sort of practical implications for firms, but also for their IT providers as well. So coming on first then to the first part of this, which is really about the overall general requirements for how firms subject to Dora manage third-party risk. And Verena and Miroslav have both talked a lot about the idea of harmonization really being key here. And the first part of this really is some general principles for managing third-party ICT risk and harmonizing those across European financial services firms under Dora. So just big picture, what we're talking about here, we're really talking about the risks that arise specifically from using third parties for ICT services, which is defined very broadly under Dora. And that should be distinguished from the focus on outsourcing, for example, under the EBA guidelines. So there's less of a focus on, is it outsourcing or non-outsourcing, and more of a focus on, are they providing ICT services? Well, in that case, the principles apply. And I think it's also important to note here that, as third parties is also considered broadly, and Dora does emphasize that this includes intra-group outsourcing. So if it's another entity within the group, say the IT service provider entity within the group that provides IT services for the rest of the firm, that's still going to be in scope. And the Commission talks about the fact that that shouldn't be considered inherently lower risk. And actually last week in the UK, we saw some more enforcement decisions in the context of intra-group outsourcing that I think are going to be raising that alarm further. So, the focus really is the focus on third-party ICT risk is because these are parties that you don't have so much control over. And so there's various measures to try to encourage, to get firms to really think about these risks and to identify them, and importantly, to mitigate them and continuously assess those risks. So thinking about some of these sorts of general principles first, Some of these are similar to what we already see under existing legislation and under existing guidelines, but they've been sort of harmonized and codified into the DORA Level 1 text. So firstly, thinking about the strategy on ICT third-party risk. So Miroslav highlighted a number of the additional sort of documents and policies that firms are going to need to put in place, including the digital operational resilience strategy. There's also a requirement to have a specific strategy on ICT third-party risk as part of that, particularly talking about the risk and the strategy of using ICT services for critical or important functions, because throughout DORA, again, the emphasis is predominantly on those ICT services and those functions where the risk of harm could be greatest, so focusing on those critical or important functions. And that would apply on an individual basis and, where relevant, on a consolidated basis across the group as well. It may also take into account multi-vendor strategies, for example, although that's not an actual mandatory requirement under the final text of DORA. And then I think there's various requirements that come into this bucket of sort of assessing ICT third-party service providers. And this applies throughout the process. You know, it starts at the pre-due diligence and pre-contractual stage, but it's really an ongoing assessment and monitoring obligation. Some of these principles are sort of familiar already, but this includes, for example, specific due diligence, and there's some detailed requirements around the assessment of risks relating to third parties, and things like ensuring they comply with appropriate security standards. And throughout DORA, there's a recognition of the compliance with appropriate security standards, and that standards can be helpful for firms where appropriate in assessing ICT risk, although they're not always adequate by themselves. Some other sort of important things to talk about is the idea of preliminary assessment of ICT concentration risk. And I think this has been one of the sort of difficult policy discussions that's raised quite a lot of interest, is this point around concentration risk in ICT. If, for example, you have a lot of financial firms that are using the same SaaS providers or the same underlying IT infrastructure. Now, it's important to distinguish here between the firm's obligation, which is to look at concentration risk within the entity. So, for example, are there multiple contractual arrangements with the same third-party IT provider that could create a concentration risk, or are there arrangements that are difficult to substitute that could also create a risk? And that should be distinguished between the idea of market concentration risk, which the regulators acknowledge firms don't have oversight themselves of which IT providers their competitors are using, for example. So that is really the responsibility of the regulators, and we'll come on in a moment to talk about that in the context of the critical IT provider supervision regime. But there is this requirement to undertake that preliminary assessment. And another thing that firms need to be thinking about and assessing, that's also been quite sort of controversial throughout the policy discussions, is the idea of subcontracting. And this is also one area that is particularly challenging for both firms and for IT service providers, including at the contractual stage. And this idea of how far down the chain of subcontracting do you need to have oversight? Essentially the idea is that firms need to be able to understand where the risk lies in the chain of any subcontracting. So they do need to have visibility of any subcontracting and have undertaken that assessment, particularly where the subcontracting relates to critical or important functions. And I think this is going to be one of the main challenges, and we're waiting for a subsequent RTS on subcontracting. So I won't talk about those other in detail. The one I will mention as well is this register of contractual arrangements. Firms under the EBA guidelines and other ESA guidelines will already have a degree of a register of their contractual arrangements for ICT and outsourcing services, but this will be more codified under DORA. There's going to be an RTS setting out the specific format of the register, for example, and reporting to the regulators on this. And that will give the regulators visibility of which IT providers are being used by whom. So coming on to the sort of documentation, which is a big part of the day-to-day of putting these arrangements in place, but certainly needs to be looked at as only one part of the broader holistic arrangements of managing ICT third-party risk. And a lot of people on this call will probably have spent a lot of time sort of renegotiating contracts for existing guidelines like the EBA and the ESMA guidelines on cloud outsourcing, for example. I think the important point, the big takeaway here is that a lot of what's in Dora in terms of the contractual requirements are similar, and sort of some of the language has been moved across from the EBA guidelines, but there are also things in here that are completely new. So one thing, for example, is more here around the idea of penetration testing and third-party providers sort of cooperating and participating in those penetration tests for critical or important functions and ICT services. Again, there's a bit of uncertainty about what that's going to look like in practice. In particular, there's a lot of discussion around avoiding the security risks of penetration testing, and we should see more detail in the RTS about what that looks like, hopefully. So I think the key takeaway really is that, yes, although some of these contractual requirements are going to be similar to what parties have already put in place with their IT providers, there are some new elements to reflect the deeper and broader scope of Dora. So the strong expectation is that contracts will need to be renegotiated once Dora is in advance of Dora entering applying. Should also just note that there are more stringent requirements for ICT services that support critical or important functions, as there is at the moment under the ESA's guidelines. And I think the Commission as a whole does acknowledge the challenge that firms sometimes encounter negotiating contractual terms with IT providers. So to share some sort of practical tips, I think, you know, there is this idea of sort of supplier fatigue and negotiation fatigue, and I'd suggest really thinking in advance about the strategy to try and minimize this and have those successful negotiations. Some of that is about allowing sufficient time, also thinking about contractual renewal timelines, but also considering overlap with other requirements in other jurisdictions. So, for example, in the UK, the operational resilience requirements and the implementation period around testing there, thinking about how the timing can be used to reduce, you know, consistent renegotiations and sort of to have those most productive conversations as possible. And I think also, you know, with this idea of taking a holistic approach to IT risk, really focusing and prioritizing those contracts for the ICT services that support critical and important functions, and taking a risk-based approach to that. So for ICT service providers, what would be some of my sort of practical and tips in practice? So I'm strongly of the view that if IT providers can make it easier for customers to comply with obligations under outsourcing requirements or Dora, for example, then that ultimately does give you a degree of competitive advantage over other competitors who make it more difficult. Obviously, though, there is a need to consider risk, in particular when we're thinking about areas like penetration testing and incident reporting. And so there is quite a bit of sort of compliance work that can be done up front to sort of think about approach to some of these issues and how to address those with your customers and also in your contractual documentation. And I think it's important to note that, you know, there are advantages to enabling customers to comply, but some of the areas that I think are going to be particularly challenging include areas like testing and subcontractor oversight, and we're waiting for more detail on those. So, conscious of time, I'll move on now to the oversight regime for critical IT providers, which I'm going to refer to here as CTPPs, which, as far as I can see, has been the most widely used acronym I've seen for critical third-party providers, because otherwise it's really a mouthful. Basically, the idea here is, you know, I think many of you will be aware of the discussions in the industry around the increasing level of use of third-party IT providers that are unregulated and how to address the potential IT and potentially systemic risk that arises as a result. And the answer that the Commission has to this is this proposed new regime for the direct oversight of certain critical providers for the first time. And this really is very new and significant for these providers that might be designated, because it would mean that for the first time, EU financial services authorities have direct supervisory powers over those currently unregulated IT providers. So we're talking, for example, cloud computing, infrastructure providers, potentially software solutions, data-related services, those sorts of things, where they are actually designated under DORA. So I think for IT providers, the key question to be thinking about at this stage is, well, is there a risk that our business might be designated? And I think to start thinking about that, it's worth looking at the designation criteria under DORA, which are going to be further supplemented by a further RTS. Now, at this stage, we can't tell whether this is only going to capture, for example, the biggest cloud providers, the biggest data service providers, or whether this could potentially go more broadly. I mean, I think it is clear that those sort of larger providers are certainly the more immediate target potentially. But looking at the designation criteria, the sorts of factors that are going to be taken into account and assessed by the authorities is looking at the systemic impact that a failure of that provider would have if they were to fail. What impact would that have on the provision of financial services to EU financial services firms? Also looking at things like the systemic character of the firms that actually rely on it, and the degree of reliance for critical important functions, and the degree of substitutability of the provider. There are certain exclusions. I mentioned, for example, ICT intergroup service provision, that is excluded, as are other firms that provide ICT services alongside regulated services. So, but it's worth bearing in mind, as a business, could the entity potentially be subject to this oversight? And if so, starting to prepare now. The key point from this diagram here is that if you are designated, although there's a limited period to provide sort of a reasoned statement, the designation applies after only up to a month. So there's a limited post-designation adjustment period to make any changes. I'm going to move fairly quickly in terms of what the oversight regime looks like, because I'm mindful of time. But as a big picture, the general approach basically is that for each designated CTPP would have a assigned lead overseer. So we'd have a single lead overseer for each critical third party, and the lead overseer would be either the EBA, ESMA, or IOPA, depending on the relative use of that provider by firms under its jurisdiction. So the lead overseer would supervise the critical IT provider and be responsible for all oversight of that critical IT provider. And then at the oversight forum level and the joint oversight network would coordinate between them to make sure there was consistency between oversight of the EBA, ESMA, and IOPA. And importantly, the national competent authorities aren't involved in oversight of the critical third-party provider, but they retain responsibility for overseeing use of that provider by the firms in their jurisdiction. As you can see on these bullet points, there's extensive oversight powers. I haven't got time to talk about these in detail, but a couple of things I will just highlight. There's extensive information and investigation powers, the ability to come and conduct direct inspections. And importantly, if these are resisted or sort of information requests aren't complied with, there is an enforcement regime that enables penalty payments to be imposed of up to 1% of average daily worldwide turnover of the previous business year, imposed on a daily basis until compliance is achieved. So the key point really is that the penalty payments are designed as an incentive to enable cooperation and to encourage cooperation of the critical third parties. Now, that enforcement mechanism for the sort of information powers and audit powers should be contrasted with the enforcement mechanism for other sort of practical recommendations that can be issued. So the lead overseer will basically undertake detailed assessments of the critical third party, looking at, for example, their security arrangements, their governance arrangements, their incident management arrangements. And if there is something that is identified as a particular concern as creating systemic risk to financial firms, then the lead overseer has the power to issue a recommendation to the firm, to the critical third party provider. Sorry. Now, something just to note is that the expectation and the hope is that the critical third party provider will take that recommendation into account and implement measures accordingly. But if they don't, firms themselves are required to take into account that sort of recommendation in how they use that critical third party. And if they don't, there is a potential as a last resort that a national competent authority could require the firm to suspend or temporarily suspend use of that provider. So I think in terms of, thinking about some key practical takeaways here, and, there's a lot more that we could talk about the CTPP oversight regime, but some of the big picture points, firstly for firms, importantly, although this is giving it oversight of the critical third party provider by the regulators, and so there's increased direct oversight of them, the regime itself doesn't reduce the burden on firms for managing risks associated with that provider themselves. I think, though, there is a broader policy discussion that's happening at the moment about whether in some ways it should reduce some of the burden on firms. If, for example, the lead overseer is conducting audits of the third party and doing their own testing, is there ways that can avoid duplication of effort by firms and on the industry? Because I think everyone is very mindful that there's a lot of compliance effort here and trying to make this, sort of efficiencies of scale, but that hasn't yet been sort of explicitly acknowledged. As I said, firms are expected to take account any recommendation issued to the CTPP and could be restricted from using the CTPP if they don't. There's also provisions in here around using critical third parties in third countries and restrictions on using those third party providers unless they establish an entity in the EU, which happy to talk further about offline if there are third country providers on the call. Just thinking about the requirements for ICT providers then and practical implications, as I said, consider if the business could be in scope, because the extensive requirements could be quite problematic earlier otherwise. And if you are in a third country, think about how it's going to impact as well. So I'm very conscious of time, and I just want to come on to some sort of broader practical takeaways about navigating Dora. So there's obviously a huge amount here. We could talk for much longer, but some key takeaways are to really stay up to date. It's still moving very quickly, and we're still waiting for a number of regulatory technical standards. The Taylor Wessing team will be following these closely, but I think it's clear that there's still a lot more detail to come. I think assess as well to what extent your existing framework and your existing compliance obligations are going to help you to comply with some of this. But I think it's clear that the requirements go significantly beyond what's already in place. At the same time, a lot of what's required under Dora is good practice and is going to help reduce ICT risk and reputational risk from incidents, cyber incidents, for example. So the sooner that some of this is done, the sort of longer you get the benefit of it for, if that makes sense. So leverage the existing framework and your existing functions and your governance arrangements, and governance is really key. And then really prepare for the new requirements. As the slide says, start early on and focus on those critical arrangements and those areas that require significant effort, like IT reporting of incidents and testing requirements in particular. But I think also, think about the contractual point as well and timing. And I think also for IT providers, what I would also say is sort of maybe start to think about what some of the opportunities of Dora might be. There are going to be a lot of firms in the EU that need more support with things like backup, encryption, security services, incident management, and there might actually be some opportunities there as well. So that's been a sort of a quick summary, but hopefully that's wrapped up, finishing with some practical considerations. And I think like to open the floor for questions. I think there's been a few on the chat, Verena.
Yes, thank you very much, both of you. That was very nice. And yeah, this was meant in a nutshell, webinar. And of course, there are lots of questions that go more into the depths of things. I can already tell you that with the follow-up email on this, you will also get the dates of the next 2 webinar sessions. So we want to make this a series. And so this is meant as a basis to everything, and then we will go into more detail. So there will definitely be a part where we compare Dora with the current regime in Germany, BAIT and so on, ZAIT and so on. But we have, maybe we can, we have a few minutes left. So there was one question. Does the ICT business continuity plan has to comprise a ransomware attack? And if yes, to pay the requested sum? I think this is not a yes or no question, but does one of you maybe want to share some thoughts on this? You see the question?
Yes, and I'm now happy to mention this one briefly. Yes, so ransomware is sort of one of the types of incidents of having response plans in place, basically, and that idea of communication plans. And I think it particularly levels of sort of coordination within the organization to know what to do in that incident. And in particularly bear in mind that if a ransomware incident happens, you might not have access to the usual sort of communication channels. So those are the sorts of things to be thinking about. In terms of paying the ransomware demand, I mean, maybe there is, I'll let Miroslav talk about the German aspect, but I know in the UK, for example, the regulatory approach is very much not to pay the ransomware demand.
Yes, I think I think Dora does not really change the approach we have now. This is something every company has to deal with at the moment as well. So this is not only something that comes into application in 2 years. It's something where even companies like our law firms, we also have to think about what will happen if we are hacked and if there is a ransomware request. Yes, and there was another question we can briefly maybe talk about if we can implement all of this on the group level as well. And I think the answer is yes, you can do this as well. Same as now, you have to outsource in the group, but you still have to make sure that the requirements are met on an institutional level, but it's the same as now. Of course you can outsource and you can use your resources within the group in an effective way, same as now, but still the higher requirements that Dora will bring to each institution will also have to be met, and also the same will apply. The responsibility of each institution will stay in the institution even if you outsource. So this is not something that will basically change.
Yeah, I would just add maybe there we can definitely take the lessons learned from other major regulatory implementation projects in the past, for instance, MiFID II, PRIPS, and so on, or sustainable finance package. So basically, we see this top-down approach. So from the parent companies, then all the way down to subsidiaries using similar processes. Of course, you need to prove to individual competent authorities in all EU 27 if you have different entities that you comply with the requirements, but pretty much the vast majority of the requirements implemented in documentation at the parent company level then can be also applied all down the chain.
Yes. Okay, so I see we have more questions, but I think we will make a cut here. Thank you all very much for your attention, and we can get back to you. Although I think there are 2 or 3 questions left, we can get back to you via email after that. So don't worry, it will not be lost. Your questions will not be lost. And we are looking forward to welcoming you again in our next session in May. We will also send you the date and all the organizational bits of this. It has not yet planned out in detail, but we will definitely do this. And yes, then thank you very much for listening in. If there are some other questions, please do not hesitate to contact us, and then have a lovely rest of the week. Bye-bye.